Just give it another minute or two just to make sure that everyone's picked a breakout room before we make a start. Okay, we might get started. Hi again, everyone, and welcome to the first of today's panels. The presentation in this panel will look at the interaction between non-state actors and international humanitarian and human rights law. Now, the relationship between non-state entities and these two bodies of law has long been the subject of scholarly discussion and debate, particularly as regards the application and enforcement of human rights norms and the laws of war against non-state actors in conflict and post-conflict settings. So, for example, although non-state actors have traditionally been considered to fall outside the ambit of international human rights law, this dominant view has been tested and questioned in recent times, with some suggesting that the human rights regime may bind and create obligations for actors other than states. We've also seen significant involvement from non-state armed groups in many recent conflicts, which has prompted questions as to how we can ensure that these actors comply with international humanitarian law and hold them accountable for any violations of such. Now, the four panels that you'll hear from today in this panel will present on topics related to this debate. First, we'll hear from Lauren Bursey, whose presentation explores the role of non-state actors in the illicit trade of cultural heritage. We'll then hear from Dennis Rabamizu and Timo Korotki in relation to the role of NGOs in documenting war crimes and ensuring accountability in the context of international armed conflicts, with a specific focus on the Ukrainian context. This will be followed by a presentation from Gayatri Kaliat, which explores prospects and challenges in ensuring the international responsibility of de facto regimes for human rights violations. Finally, Tanya Atalano will present on the application of international humanitarian law by non-state armed groups using the example of the Chiapas uprising. Each speaker has about 15 minutes to present, which should leave us just under half an hour at the end for discussion and questions. During this discussion period, we'll invite questions from the audience and from the panelists to one another. So if any members of the audience have questions that come up during the panelists' presentations, please feel free to leave them in the meeting chat and we can return to them at the end. Also, to ensure that each panelist has an opportunity to speak and that we have sufficient time left for discussion, I will be interjecting somewhere around the 15-minute mark to warn panelists that they are out of time if they're still going at that point, after which they'll be allowed a further minute to finalise their presentation. So I think you've all heard me speak for long enough at this point in time, so I will hand the floor over to Lauren Bursey for her presentation. Thanks, Lauren.
Thanks, Georgia. I'm going to share my screen for my presentation. Can everyone see that? Okay, can you see just the slide, the title slide now?
Yeah, we can see. Thanks, Lauren.
So as Georgia mentioned, today I'm going to be talking about non-state actors in the illicit trade in cultural heritage. The trade in illicit cultural heritage is immensely complex, regulated by a transnational system of laws, which include international treaties on the destruction of heritage and armed conflict, customs laws, domestic criminal laws, and non-binding guidelines. This is a wide-ranging, high-profile area with prominent examples highlighted in media that I'm sure you're aware of, covering everything from the issue of the restitution of objects looted in the 19th century, such as the Benin bronzes, the ongoing dispute over the Parthenon marbles, and the more recent scandal of the British Museum employees selling objects on eBay. From a legal perspective, the key issue is that despite there being a plethora of transnational laws protecting cultural heritage, and to prevent the illicit trade in antiquities, heritage continues to be destroyed, looted, and transacted in international trade. Looting is the greatest source of damage to heritage compared with other forms of destruction. Therefore, it is safe to say that the laws in this area do not work to ensure the safeguarding of cultural property. This picture on the front here is actually to demonstrate the looting, the pockmarked holes from looters in Syria following and during the civil war. So today I'll briefly go over some of the history of the laws surrounding cultural heritage, describes an example of armed conflict and their laws in Syria, and look at non-state actors in the global trade. My main argument here is that states remain the primary line of defense in the protection of the illicit trade in antiquities in the 21st century, but they can't adequately enforce the transnational laws in the illicit trade and are not best positioned to do so because of their distance from the trade itself. Non-state actors should be incorporated into the transnational legal framework, protecting cultural heritage and prohibiting the trade in illicit antiquities as sources of and enforcers of regulation, but also the perpetrators of destruction. Early interventions in cultural property were attempts to codify the law of war where no treaties protecting cultural property existed. However, efforts to codify the laws and customs of war with the protections for religious, artistic, and scientific property coincided with several military expeditions that resulted in the looting of the heritage. In the age of war, where war needed to be declared by the sovereign against another sovereign and not against the local population, these laws were ignored or patently inapplicable. Thus, these foundational laws were created when non-state actors were benign, and armed non-state actors in particular were colonized people and therefore given no due consideration by default. In 1954, following the mass destruction of World War II, and at the same time as the international community drafted other humanitarian treaties to deal with the mass killings under the auspices of UNESCO and its General Conference, with cooperation from the International Council of Museums, the International Committee on Monuments, Artistic and Historic Sites, and Archaeological Excavations, 37 states signed the Hague Convention for the Protection of Cultural Property in the Event of Armed Conflict and its first protocol, which aimed to maintain a balance between humanitarian and military requirements while preventing the exportation of cultural property from an occupied territory, although numerous concessions were made to demands of a military nature. Notably, the convention aims to protect monuments and works of art not as the national heritage, but as universal heritage, to be safeguarded for the benefit of mankind as a whole. Thus, it solidified the system of protection as an international matter, not merely a domestic issue, while theoretically placing responsibility on all actors, regardless of nationality. Laws concerning the trade did not come until much later. The very nature of trade in cultural heritage, whether licit or illicit, moves an object from one country, the source country, to another, the market country, passing import-export laws, middlemen, government officials, tax regulation, and commercial sales law. The source country may be experiencing a period of armed conflict and instability, with insurgency groups taking advantage of looters, smugglers, and dealers, all trying to make a profit to live or support the conflict. The object may have been legally looted from the ground, smuggled across a border, sat in a warehouse at a free port in Switzerland, being sold to a dealer who does not ask questions, and consigned to an auction house in London with false provenance. Only in about the past decade, and only among the top auction houses and dealers, has an object's provenance ever been inquired into. The entire supply and demand chain can be explained through these non-state actors. The first group is looters of source country intermediaries, and follows the supply chain and the trade, starting with the looters in the local communities and armed conflict zones. Next is the market country intermediaries, the largest category, who include auction houses and galleries, art dealers, lawyers and agents, and trade organizations. Finally, the collectors themselves. The non-market actors play more of an academic and advocacy role and include NGOs, policy think tanks, archaeologists and anthropologists, and scholars of law, economics, and international law. There's also exists a third group of unarmed actors who operate in a gray area between a state and a non-state actor. UNESCO and museums, both public and private, fit into this category. As entities, they're harder to classify because they are composed of a variety of actors with different ties to either state or the market or an academic and advisory role. In Syria, where proxy states were set up, multiple armed non-state actors attempted to govern, and cultural heritage was targeted once again by all parties, despite transnational efforts at addressing looting and trafficking. Conflict has been defined not only by the large amount of armed non-state actors and proxy groups, but its deliberate and wanton destruction and looting of cultural heritage. Once Syria entered into conflict, cultural heritage became one of the casualties, as heritage sites became part of the battlefield and movable heritage was looted. When ISIS intentionally attacked the ancient temple of Balshamin, Temple of Bel, and the Arch of Triumph in Palmyra in 2015, it signaled to the broader community that culture was a key element of the Syrian conflict. It is important to remember, as noted before, that the challenge with acquiring accurate information on the illicit trade, and especially in war zones. Heritage groups on the ground are often small and underfunded, resulting in high levels of circular reporting and grapevine distortions and corruptions of data. Our understanding of cultural heritage protection is based on the belief that states can protect cultural heritage. The Syrian war demonstrates the falseness of that assumption, as Syria can now be classified as a failed state and has thus been unable to meet the bare minimum required to enforce legal standards. Combat damage and widespread looting are common in Syria, and all major combatants, state, quasi-state, and non-state, are responsible for acts of theft and destruction to varying degrees. There's been demonstrated gridlock within UNESCO operations in Syria, which demonstrates the problem with its institutional rules, which prohibit engagement with non-state actors, even when the state has lost control over its sovereign territory. How might the law of state responsibility and occupation in enforcing the laws against armed non-state actors and impact the role of the market states, such as the UK and the US, in countering illicit trafficking as a result of this war? Heritage in Syria has faced destruction from numerous factors, including looting at 25%, illegal digging, combat damage, illegal construction, and deliberate destruction. In many ways, it can be argued that other market categories Other market countries, notably the US and the UK, have, at the international level, abrogated the responsibility for preventing the illicit trade at its source and the destruction of cultural heritage to UNESCO. At the domestic level, these countries have enacted specific regulations, but these only deal with import restrictions rather than the fundamental problems in the source country. This is an institutional challenge and a challenge with the structural setup of public international law. The reality demonstrates that the problem is not simply about whether the laws work or not, but is rather a challenge of how states engage with a transnational issue. The entire framework of preservation and anti-looting is nevertheless largely reactive, interfering with heritage only after damage has been suffered. At the same time, coming back to the non-state actors on the ground, civilians are involved in looting and smuggling of cultural heritage. Under ISIS, looting was often conducted by others and taxed by them, where motivations and economic underpinnings for the actual looting were highly varied, including greed, economic stress such as unemployment, exacerbated by armed conflict, or environmental stress such as droughts or low crop yield. Unfortunately, the Hague Convention only condemns military personnel and their actions and does not condemn civilian thefts. Antiquity trafficking is complex and chaotic, a reality that the laws do not account for. Once the objects are looted from the ground, who is there to enforce these laws? With a failed state where the state representatives are themselves involved in looting, the international legal regime becomes all the more important. But once we enter the trade, the laws involved become primarily domestic. Despite customs laws and export restrictions, there are reports that many artifacts are hidden in sacks of flour, trucks full of other commodities, or in boxes in car trucks. Taxis drive goods across borders, and one smuggler has used villages on the Iran-Iraq and Iran-Turkey borders to smuggle items where the villagers use donkeys and mules to carry the goods and bribe border guards. Once the objects get to London, the transnational regime becomes more domestic, where the laws focus much more on the purchase of the items than the items themselves. It can be said that only in the past decade has the emphasis on buyer due diligence become a norm, and that is not even a straightforward concept, varying between individuals and actors and nationalities. While the UK has enacted the Dealing in Cultural Objects Offences Act, which states that a person is guilty of an offence if he dishonestly deals in cultural objects that's tainted, knowing or believing the object is tainted, the definitions of this are quite ambiguous, and enforcement is sparse. While the Act was aimed at changing the culture of the marketplace to encourage more due diligence and general good practices, the Act was not ultimately invoked until 2016, and is not retroactive, and has not been used thus far in any dispute until the theft from churches in England and Wales. Currently, there is no legislation which governs the activities of art galleries and art dealers or agents. This was one reason for the Responsible Art Markets Toolkit for Art Market Professionals, which was a guideline for responsible and ethical transactions in the art market. Aside from joining groups like RAM to police themselves, art and cultural heritage intermediaries are also represented by trade organizations who engage in advocacy on behalf of their members, such as the British Art Market Federation, which is intertwined with the new rules against money laundering that are being enforced in the UK and the European Union. Thus, the trade organizations representing the auction houses have a strong role in policy making within the state, and there can be little doubt that these 8 groups aim to shape policy in the interests of the trade foremost, and not of the market countries and their humanitarian concerns. Collectors are arguably the most important non-state actors in the trade for cultural heritage, and by extension, its looting and destruction. They're the drivers of the trade at the top of the demand side of the equation. It's easy to vilify collectors for this reason alone, as many archaeologists do. At the same time, collectors can be philanthropists, donating both money and objects to museums, allowing for the preservation of museum collections and the continuance of research. While there have been several high-profile collectors who have run afoul of the law and up against ethical concerns over their collections, archaeologists remind us that these big-name, newsworthy examples provide only a small picture of the demand side. In reality, there exists a sizable trade in small, inexpensive objects aimed at limited pockets of collectors who are interested in relics or curios as much as treasures. As explained earlier, in the different ways objects can make their way across borders, these smaller objects can be easily slipped into someone's pockets. Unfortunately, both policy decisions and lawmaking focus on and respond to the instances involving high-value supply chains, connecting dealers to wealthy collectors, and fails to capture the more dispersed, opportunistic, and less specialized criminal networks that exist alongside and is also driven by collector demand. While the collectors themselves may not be lobbying, the collectors create the demands that cause the trade associations and the auction houses to lobby for the continued trade, and the demand causes an increase in looting and resulting counter legislation. A RAND report suggests this analysis of collectors who exist outside of the wealthy Western stereotype, describing collectors in Turkey and Iran who are buying items for prices similar to what would be paid in the US and London. I'll just conclude by noting that the role of non-state actors has become more complex and the categorization of their operations more murky, especially as armed non-state actors have entered the market amid a changed state of warfare and geopolitical realities. Thank you.
Thanks very much, Lauren, for that very interesting presentation. Next, we're going to hear from Dennis Rabamizo and Timur Korotki. Thanks, Dennis and Timur.
Thank you, Georgia. I hope everybody hear me well. Hello, good afternoon. So our presentation relates to the role of non-governmental organizations in documenting war crimes and ensuring accountability in the context of the armed conflict. My co-author and I are representatives of two interrelated activities. I'm a practitioner with experience in international law, arbitration, and human rights, and my co-author, Professor Timur Korotki, is an academician, lecturer, IHL expert, and the head of the Fundamental Research Support Fund. Since March 2022, we are both involved in documenting war crimes and preparing analytical materials as part of the activities of the coalition of NGOs called Ukraine 5 AM. I was involved in and still involved in this activity as an expert of the coalition and coordinator of the direction of war crimes documentation. In my work, I'm more focused on creating digital databases that would allow archiving the collected information, sharing it with others, and using it for investigation and analytical work. My colleague, Professor Korotki, has been actively involved in documenting war crimes, for example, against cultural property and religious sites, taking part in many field missions for these purposes and preparing a number of analytical materials. In our speech, we would like to talk about our experience and observations that we have had in the process of our activities, especially since February 2022. The participation of public organizations in the recording of wartime events is of particular interest to study, and the Ukrainian experience, in our deep conviction, is truly unique. Nowhere before and now can we find such an experience which can be interesting for others. This is why in our speech we would like to talk about it and show it through the following three main settings, only three. The first one is the high level of development and preparedness of civil society for documenting war crimes and taking actions to hold Russia accountable. The second one, documentation takes place practically in real time. And the third one is the scale of documentation covers at least the entire territory of Ukraine. Let us consider these three theses in a little more detail. Regarding the first one on the development and preparedness of the civil society, in Ukraine, it didn't happen overnight. Here we can distinguish three main periods for NGOs. The first period covers the period before 2014, when civil society was mainly focused on domestic issues such as the implementation of necessary reforms, the fight against corruption, and other issues. In that period, there was no war, and it was not in the active focus of civil society organizations. The second period is the period from 2014 until the beginning of 2022. This is a period to which a new topic has been added and related to Russia's occupation of the Crimean Peninsula and parts of Lugansk and Donetsk regions. During this period, work began on documenting war crimes in the occupied territories, working out various options for bringing Russia to justice. During this period, extensive trainings on international humanitarian law are held. Analytical reports on issues related to human rights violations in the occupied territories are prepared. Such information is transferred to international institutions, including the Office of the Prosecutor of the International Criminal Court. Advocacy activities are also carried out at various international platforms, such as the Organization for Security and Cooperation in Europe, the United Nations, and so on. In my personal opinion, by the end of 2021, there was a certain lull in such activity, as much of what could be done had already been done, and it remained to build long-term plans to advocate for the return of the occupied territories. However, despite this, in our opinion, this period was a period of educational and technical preparation of public organizations for what happened next. It was during this period that the study of international humanitarian law became popularized among lawyers, advocates, and judges in Ukraine, even for some structural units of law enforcement agencies and prosecutors' offices involved in the investigation of war crimes. Special trainings on international humanitarian law were conducted. The third period started on 24th of February 2022, when everything was changed. From the first days of the war, we began to gather again in groups to resume documenting war crimes, and we were so numerous that the decision was made to form a coalition of public organizations. It was already obvious to all of us that we were facing a tragedy on a scale that could not be handled by one or a few organizations. And it was important for us to unite together in order to be more effective in our work. This is how the 5 AM coalition was formed as a response to Russia's full-scale invasion of Ukraine. The name 5 AM was taken from the time of the first rocket attacks on Ukraine on the 24th of February 2022. Since COVID-19 pandemic taught us how to work online under sharing and evacuation conditions, we quickly began to gather for online meetings and discuss further actions. We had an action plan almost immediately, as all we had to do was to resume our previous activities and scale them up to several times over. Today, the coalition consists of 38 organizations, each contributing to its development by engaging in one or more of its core activities, including documentation, analytical and informational activity, and advocacy. Half of these organizations are involved in documenting war crimes in one way or another. And that is why we argue that the previous experience of training specialists in the field of international humanitarian law among representatives of civil society organizations played an important role in the rapid start of the documentation of war crimes on the territory of Ukraine. At the same time, it allowed to start the process of communication with law enforcement agencies and international organizations to bring the perpetrators to justice. Here, furthermore, we move to the second thesis, which relates to documentation in near real time. From the first days of the war in Ukraine, hundreds of chat rooms began to form in Telegram and other social networks. In these chats, people shared up-to-date information about what was happening and where. It was about the results of shelling, civilian hostage-taking, killings, and so on. At first, we had almost no access to victims and witnesses. in the first days, and all we had to do was document events based on open source information. In order for this work to be useful for any potential future legal processes, we needed a standard for properly capturing open source information. Such a standard was the BIICL Protocol on Digital Open Source Investigations, developed by the Human Rights Center at the University of California, Berkeley School of Law, together with the Office of the United Nations High Commissioner for Human Rights. We organized its translation into Ukrainian and immediately began to hold one after another trainings for volunteers who were ready to join our documentation work. Such trainings took place almost every day. The number of volunteers was large and not constant, as not everyone was psychologically ready for this kind of work. Already in March 2022, approximately over 1 month when Russia invaded Ukraine, we created the first evidence database in the cloud and the first registers of events, victims, and witnesses. By the end of March, it became obvious that the amount of information we were seeing daily in open sources was almost impossible to capture quickly. There were cases when Russian military officers, bloggers, and politicians published information valuable to document and then quickly deleted it. In such situations, we didn't always have time to record such information properly, often leaving only screenshots for ourselves. That's why we started looking for a digital solution to capture evidence in open source. This led us to collaborate with an organization such as Mnemonic. Together with them and Bellingcat, we started to create the Ukrainian Archive, a database of information from open sources. Today, it's probably the largest archive they have created before, and it already has more than 5 million pieces of different information, photos, videos, text messages, allowing to save both the content itself and what is important, its metadata. Work on this extraordinary archive continues today, mainly in automatic mode by means of present settings. Then, starting in April 2022, we began to have more and more contact with witnesses and victims. They reached out to us through coalition member organizations, our coalition mail, and in other ways. Many organizations became involved in obtaining testimonies from them about what they had seen and experienced. In order to avoid duplication of work and minimize trauma to the individuals who were interviewed, we began looking for a software solution to create a single database that would bring together all evidence databases of each organizations and from Mnemonic and allow for collaborative work to document, investigate. It would avoid duplication, and such a database began to be built with Case Matrix Network in late 2022, and is now populated daily by more than a dozen analysts. And turning to the third thesis, that the scale of documentation covers at least the entire territory of Ukraine, we want to say that as of March 2022, Russia occupied 27% of Ukraine's territory. This is more than the size of the territories of Bulgaria and Hungary combined. Today, this percentage is slightly less due to the successful offensive actions of the Ukrainian armed forces. However, along with the occupation of Ukrainian territories, Russia's forces brought with them war crimes, which they actively committed primarily against civilians. Witnesses and victims of war crimes were forced to move not only within Ukraine, but also far beyond its borders. This in turn forced us to seek our victims and witnesses wherever we could find them in order to interview and to conduct field missions to places that had been deoccupied. For example, in the first half of 2022, these were the Kiev, Chernihiv, and Sumy regions, and in the second half of 2022, partly the Kharkiv and Kherson regions. Often, field missions are conducted in cooperation with law enforcement agencies, which in most cases do not have adequate knowledge of documenting war crimes specifically. Speaking of all these achievements, it's important not to mention the challenges we face. Among them, I would mention the following. The first one is, despite the training of most of the staff of civil society organizations in international humanitarian law, we still lack trained personnel to do more analytical work. The second is, the amount of information to be documented is so large that we are still involved in the process of training new analysts and documentators. The third one, all of this work would not be possible without funding. We have done a great deal in the first months of the war in 2022 through the involvement of volunteers and with our own funds. But sooner or later, the scale of such activity begins to require funding for salaries, travel, equipment, trainings, security, and it all requires funding. We are grateful to our donors for their support last and this year. And also, the last but not least, is the safety of those who are involved in documentation. Examples of this can be seen in the deaths of our colleagues who were killed by rocket attacks while carrying out their documentation work. Sometimes we are asked why we document war crimes when it should be done by law enforcement agencies. We do it to fulfill two main goals that we have set for ourselves. The first one is to realize the right to the truth, and the second is to bring the perpetrators to justice. We want and are actively working to ensure that even in 50 years, the memory of events that are currently taking place in Ukraine will be preserved. Perhaps it will be one of the most documented war in the world. We believe it's important that NGOs actively engage in the meticulous documentation of war crimes, serving as independent observers and chronicles of human rights violations through fieldwork, first-hand accounts, and the collection of evidences. These organizations compile comprehensive reports that detail the extent and nature of atrocities. By doing so, NGOs contribute to establishing an accurate historical record, preserving the memory of victims, and creating a foundation for legal action. We also want the perpetrators to be held accountable for the crimes committed. That is why our NGOs in Ukraine cooperate with law enforcement agencies in Ukraine and abroad, communicating with international institutions, the ICC Prosecutor's Office. We hand them the collected materials, initiate investigations, use the collected material in order to advocate support for Ukraine, increase sanctions pressure on Russia, and bring the perpetrators to justice. We believe that even the ICC warrant to search for Putin was adopted and concluded with the information we collected and passed to the prosecutor's office. Our materials are also used in interstate disputes such as Ukraine against Russia in the European Court for Human Rights. Ukrainian experience proves that the role of NGOs in documenting war crimes and ensuring accountability in the context of international armed conflicts is indispensable. Dedication of public organizations and civil society to justice, human rights, and the rule of law contribute significantly to the prevention of impunity and the establishment of a more just and human world order. As key stakeholders in the pursuit of accountability, NGOs continue to be instrumental in shaping a future where the horrors of war are met with unwavering commitment to justice and accountability. Thank you for your attention to our presentation.
Thank you very much, Dennis. Now we'll hear from Gayatri Kaliyat.
Thank you so much, Georgia, and thank you also to BIICL and SLS for giving me this opportunity to present a part of my DPhil work. My name is Gayatri, and I'm currently doing my PhD on the precise topic that Georgia mentioned earlier, which is the international responsibility of de facto regimes for human rights violations. And I've titled this presentation as Prospects and Challenges precisely because I'm still in the process of gleaning these prospects and challenges and understanding whether there is even a potential for talking about a responsibility regime that is specific to de facto regimes. So I look forward to hearing everyone's thoughts, to be honest. For starters, I do want to, at the cost of stating the obvious, define DFRs. So in my work, I do see them as non-state entities which exercise governmental authority and effective territorial control, and importantly also claim to be independent states, although the international community does not recognize them as such. And such de facto regimes, as we all know, are quite complex in that their international legal personality is still heavily debated. But interestingly enough, they are a common occurrence today. So some of the examples that are of interest to me include, the so-called republics, as many scholars try to refer them to as, so including the Turkish Republic of Northern Cyprus, the Transnistria, Artsakh, Abkhazia, South Ossetia, Somaliland, the Kurdistan region, Western Sahara, to name a few. Much has already been written about the responsibility gap that such de facto regimes create in a state-centric human rights protection system that we have within international law. And like Georgia was mentioning earlier, in recent years, much has also been said about the human rights obligations that non-state armed groups, particularly those like DFRs, which also have effective territorial control, have under international law. And a lot of scholarly literature already, relies on state practice, the practice of international organizations, and also the wealth of literature that's coming from UN human rights treaty bodies, as well as UN special rapporteurs, to talk about how there is an emerging trend in recognizing the human rights obligations of DFR. So I don't want to spend too much time on that element, but what I'm interested in understanding is what next? What once we have acknowledged that these entities have human rights obligations, is it time to also then talk about responsibility? So specifically, what I try to do in my work is assess whether the de facto regimes can bear direct international responsibility for their human rights violations as non-state actors. And if yes, then what rules do or potentially could form part of such a DFR responsibility regime. But before I get to that second question, at the outset, I do think it's worth clarifying that when I say responsibility, I do mean legal responsibility of a DFR to make reparations for violating an international obligation, and not just accountability as a broader notion. And secondly, a clarification I want to offer is that the focus of my work is very much on the responsibility of DFRs as a collective entity, and not just the individual responsibility of, say, specific actors within a DFR's governmental apparatus. Needless to say, there is currently no regime of international responsibility of DFRs, certainly not specifically for violations of human rights law, and certainly not as collective entities. But in my work, I argue that this is very much the need of the hour, because firstly, individual criminal responsibility, or even the solutions that international criminal law offers, even in respect of collective actions, tends to be limited, precisely because not all human rights violations are captured within international criminal law or the system of individual criminal responsibility. We're still very much in the realm of talking about the most serious or the most grave human rights violations. The second reason why I think it's useful for us to consider a collective responsibility regime is simply because DFRs, much like states, are collective entities. They do have quasi-statal institutions, and much of the decision-making in a lot of these DFRs tends to be a collective process. And by virtue of that level of organization, I still think it's important to think about this from a collective responsibility perspective. And finally, as some individuals at the ICRC, including Luc Moffett, identify, encouraging the collective organization of non-state entities, especially non-state armed groups and DFRs with territorial control, to make reparations tends to be more productive. And this is what they say based on a lot of on-the-ground, bottom-up research. And they say that this may lead to the mobilization of more resources for offering reparations. So even from a victim perspective, therefore, it may be better to think about a regime of collective responsibility as opposed to individual criminal responsibility. That said, there's also, several challenges to recognizing a regime of DFR responsibility, not the least of which are obviously the problem of DFRs not having international legal personality or their formal legal status still being debated. And secondly, also the very sort of legitimate risk of running into a legitimization problem that a lot of states seem to have when it comes to recognizing even the obligations of DFRs, which they essentially see as an indirect way of legitimizing the existence of these organizations. I don't want to spend too much time on addressing these challenges per se, but very briefly, I think it is time to move beyond thinking exclusively about these challenges because the promise of the universality of international human rights law is just going to remain empty if we don't try to find ways to navigate these challenges. Even a simple solution like acknowledging, say, in special agreements with DFRs that entering into that agreement or recognizing their responsibility or obligations does not in itself mean that they are now a legitimate entity within international law, may be an adequate solution to then ensure that there is compliance with human rights law. I do want to now jump right into the potential responsibility regime for DFRs. And in terms of methodology, I think I am following the path that has been laid down by other academics and scholars who talk about the responsibility of non-state armed groups more broadly. So I do, much like them, rely on the articles on state responsibility as well as the draft articles on the responsibility of international organizations and use these as a starting point to then talk about what kind of rules may benefit a regime of DFR responsibility. And I do realize that one of the challenges here is the possible replication of the weaknesses that are already existing in the articles on state responsibility and the draft articles on IO responsibility. But the only solution that I can see is to try and adapt these norms to the extent possible, depending on the specific characteristics of DFRs, which, like a lot of other non-state actors, I believe, sort of straddles that line between a state and a non-state actor, in that, much like states, DFRs also have effective territorial control or governmental authority and a lot of quasi-statal institutions. But at the same time, they don't have the same level of recognition as most other states have. So we are still stuck in that realm of treating them as non-state entities and seeing what we can do in terms of realizing their obligations and responsibility. So in order to make these minimal sort of adaptations to the character and nature of DFRs, I rely on a lot of, in common parlance, soft law instruments. I do, to the extent possible, try to see if state practice gives any leads. But in a large majority of these cases, state practice in itself doesn't give a lot of leads, but there is important work that is coming out of, say, the practice of international organizations or UN human treaty bodies, UN special rapporteurs, fact-finding missions, commissions of inquiry, etc. And equally, I think there is value also in looking at the practice of DFRs itself to see to what extent their practice aligns with what all these bodies are saying, and potentially also what states are saying about the human rights obligations of non-state armed groups more generally. So that is basically a precursor to now my responsibility regime itself. I have so far only managed to explore three themes, the first being the attribution of conduct, the second being the content of responsibility, and the third, to an extent, being the invocation of responsibility. So on attribution of conduct, I think, we start off with the most primary rule, which is the possibility of attributing the conduct of the organs of the DFR or the agents of the DFR to the DFR in itself. And I think we've already had some leads in this direction. So, for example, Robert Argo in the third report on state responsibility to the ILC already speaks of how, the actions of insurrectional movements, individuals and groups who belong to the organization of an insurrectional movement can be attributed to that insurrectional movement. And since several of the DFRs that are under consideration in my work have organized themselves pretty much similar to states, we do see that, within their constitutions or within their political and legal systems, they've already recognized certain entities as being their de jure organs. So that sort of determination of who is an organ and whether their conduct will be attributable to the DFR or not seems to be pretty straightforward. The second rule is, of course, the effective control tests that we see within the state responsibility context. And I believe because of the similarity between the way states and DFRs organize themselves, efforts like the 2009 Independent Fact-Finding Committee on Gaza sort of proposed to apply this effective control test to attribute the conduct of certain armed factions in Palestinian territories to the Hamas. To quote them, they literally say, Hamas ultimately had effective control over the actions of these armed factions and therefore should be held responsible for these actions. So I believe there is some practice already which hints at this possibility. However, both in respect of the previous rule and the current one, I think Crawford's first report on state responsibility offers an important cautionary note, which is that one cannot attribute the more or less uncoordinated conduct of the supporters of such a movement to DFRs. And this, I believe, is an interesting distinction to be made because otherwise we may find ourselves falling into the trap of attributing mere ideological associations of certain individuals as being, sufficient to hold the DFR responsible, which is certainly not the ideal way forward. The third rule that I look at is naturally acknowledgement and adoption of conduct. And it is interesting to see that DFRs do on occasion accept responsibility for specific actions. So one of the examples that stood out to me this year was Somaliland accepting responsibility for the killings of civilians by their security forces in Lasa Nord. So there is DFR practice which sort of shows that such acknowledgement of conduct happens, and you do have UN monitoring bodies, especially the Special Rapporteur on Summary Executions, who has said that such acknowledgement is also a good way to attribute conduct to non-state actors. Apart from attribution, of course, attribution only goes so far. So beyond attribution of conduct, I believe there is also some literature to suggest that due diligence obligations may be playing an important gap-filling role. So, for example, the UN fact-finding mission on Gaza back in the early 2000s said Gaza authorities are obliged under international law to control the activities of armed groups operating on the territory under their control. So this broader due diligence and notion of due diligence, I believe, would also do some important gap filling. To very, very briefly touch upon the content of responsibility, this once again largely mirrors and is comparable to that of states and international organizations, and we already have the UN's basic principles and guidelines on the right to a remedy and reparation for victims of gross violations of IHRL, which talks about pretty much the same forms of responsibility that are recognized within the articles on state responsibility. So cessation, reparations, satisfaction, etc. And we do see that very often the practice of DFRs also aligns with these. So for example, you have the Constitution of the ARTSAC, which recognizes specifically under the section on fundamental human rights, that everyone shall have the right to compensation for damage that is inflicted through any illegitimate actions of the Republic of Artsakh. Similarly, you have the deeds of commitment that a lot of DFRs, such as the Polisario Front in the Western Sahara context, have entered into with an NGO, Geneva Call, confirming that they have an obligation to cease the use of anti-personnel mines. And finally, on invocation of responsibility, I believe international law already appears to suggest that states, specifically territorial states and other third states that may have some influence over the DFR, have an obligation to invoke the responsibility of DFRs. And I say obligation to invoke the responsibility of the DFRs because that is exactly how courts like the European Court of Human Rights sort of term it. So it's not merely an entitlement to invoke the responsibility of DFRs, but rather a duty. So the specific case that I have in mind, of course, is the Ilascu versus Moldova and Russia judgment before the European Court of Human Rights. Without entering into too much detail, I believe most people may be aware that the European Court of Human Rights talks about how Moldova as a territorial state has certain positive obligations to essentially engage with any actor, including the de facto authorities in Transnistria, as well as Russia, who has influence over the Transnistrian authorities, engage with them to find diplomatic solutions and also press upon the specific applicants' sort of misery in front of these authorities. So that's sort of a clear sort of recognition of an obligation, I think, is an indication that Moldova is expected to invoke the responsibility of Transnistrian authorities. But to very briefly also pick up on the point that was being made earlier about how state centricism itself may be the root cause of all these problems, I do propose in my paper about the possibility for international organizations, individuals, and also non-governmental organizations to invoke the responsibility of DFRs. So an example that I have in mind with NGOs is the Deeds of Commitment by Geneva Call. So the Polisario Front Deed of Commitment that I was talking about earlier very specifically recognizes that Geneva Call, or potentially any other national or international organizations that they identify, can monitor and verify whether the Polisario Front is actually committed to banning anti-personnel mines or not, which I believe is a good way of invoking the responsibility of these DFRs. Yeah, so to conclude, I do think that international law is already progressing in the direction of acknowledging the responsibility of DFRs, although there is a lot more to be said. And the one point that I haven't really said much about in my work so far is the idea of shared responsibility between the DFR and the territorial state and third states as well. But yeah, I would love to hear your thoughts if you have any guidance on how to take this forward. Thank you.
Thanks so much, Gayatri. That was very interesting. And our final panelist for today is Tanya Atalano. Thanks, Tanya. It looks like Tanya may have dropped off the call. We'll give her a moment to come back, but in the meantime, we might open the floor up to the audience for any questions or discussion that they have.
I'm here again.
Wonderful, Tanya. We'll get started with your presentation then. Thank you.
Sorry, so I got a problem here with the internet. So I'll share my Okay. So, do you see it? Yes. Okay. So, thank you very much for having me here, and also for being in this wonderful workshop. So, I am, my topic today is about a specific example of application of international humanitarian law by a non-state armed group, which in this case is the
It looks like we've lost Tanya again. So we might give her just a moment to return before we turn over to questions. Thanks for your patience, everyone.
Okay. I'm sorry, something is happening with my internet.
No problem, Tanya.
But do you
it?
see the presentation? Yes.
We can't see your screen anymore.
Oh, okay, wait a second. I hope. Okay. So hopefully it won't be interrupted again. Okay, so yes. So my case is about the Ejército Zapatista de Liberación Nacional. Yes, so in 1994, the Ejército Zapatista de Liberación Nacional, Zapatista Liberation Army, declared war to the Mexican states. Now, as you might know, Chiapas is located in the southeastern part of Mexico, and there, out of 111 municipalities, 99 have a majority of indigenous population. So let's say like their main claim was vindicating indigenous groups and just reaching basic human rights like right to health, to education, to free education, and so on. And so what is very interesting is the formal declaration they made on January 1st, 1994, which is called the Declaración de la Selva Lacandona, Declaration of the Lacandona Jungle, which is actually a formal declaration of war. Now, as you know, the formal declaration of war was codified in the Hague Conventions of 1907. Of course, here, the novel thing is that it is a non-state armed group that is declaring war to a state. And so it is also a unilateral declaration to abide with the laws of war, as we will see next. But first of all, I would like to say a little bit about the background of this, so to speak, declaration of war against the Mexican state. First of all, they condemned the 70-year party dictatorship we have in the country. So they wanted to denounce this party dictatorship, and they longed for democratic change of of government, and also to restore legality in the country. And they resorted to article, as a justification for this declaration of war, they resorted to Article 39 of the Mexican Constitution, where power is based on popular sovereignty and where the people has the right to change their form of government. Now, the very interesting thing also about the Declaración de la Selva Lacandona is their contents, which we will see now, in which they unilaterally abide and adhere to the Geneva Conventions. Now, first of all, as we said, so first of all, they are formally complying with the requirement of declaring war, so they are declaring war, and they are abiding themselves to the protection of civilians, which here they would fulfill Common Article 3 of the Geneva Conventions, as well as Articles 14, 15 of Geneva Convention 4. As I said, they are subjecting themselves to the Geneva Conventions. They are also inviting in this declaration to international organizations and the ICRC to monitor and regulate combat. What else? They are demanding also unconditional surrender of the enemies before engaging in combat, which would comply with Article 23b of the Hague Conventions of 19.
Thanks for your patience, everyone. We'll just give Tanya another moment to rejoin and continue her presentation. Okay, it looks like we might just need to move to questions and discussion period. So if any of the members of the audience or the panelists have questions for Dennis, Lauren, or Gayatri, if you would like to either unmute yourself and ask the panelist directly or post a question in the meeting chat, please feel free to do so.
I did have a question for Dennis. Thank you so much for your presentation. Like it was really fascinating to see really, how international law, in order to put international law into practice, there's so much that goes on behind the scenes. And I really appreciated how you also sort of try to explain the challenges that you faced in putting all this evidence together. And I just had a question there about whether you also encountered a challenge of verification, because from what I gather, a lot of the open source material that you were sourcing were also just videos that potentially were accessed via social media. Did you also, I don't know, run into the problem of doctored footage, any manipulative information, and is that something that you had to tackle, or was somebody else, anybody you were collaborating with tackling those challenges?
Thank you, Kaysri, for your question. It's a good question, really, and we think about it from the very beginning when we started documenting war crimes on the basis of open source information. And it's always challenging because you cannot check or verify everything that you will receive. But I can say just we can verify some information in comparison with other sources of information. We cannot take open source information as a basis for our analytical job or for any results or for any kind of reports. We always try to check this information published in the open sources through different source information just to check if it's correct or not. Also, we can verify information by means of source if this source of information publish from time to time not correct information. We are very cautious about it. And the third one is we just start in investigations on the basis of different source information on in relation to particular crimes. And of course, we also try to look more deeply through when it was published, who published this information, which kind of information it contains, and so on. So even when we look at videos with some publications, we look carefully and try to relocate this information and so on. So we're very cautious about verification of information from open source. And it's true, it's a very long process. It doesn't take just one day, and it requires a lot of time and a huge group of people who are involved in investigations. I also can add that till present, we just started, because there was a lot of information. We just started to collect everything that we can. And only 1 month ago, we started the process of verification of some kind of information. If we say about information from open source and about Ukrainian archive, which we create together with Mnemonic and Bellingcat and some others organizations already who are joining us in this activity, of course, this archive contains a lot of information which is not verified at this stage, but we are just developing a methodology how we will verify this information, how we will tag it inside of the Ukrainian archive just to use more effectively for the future work. So we just start this process, and if you can imagine, when we have already more than 5 million pieces of different information, it means that we need a lot of time and a lot of people and a good agreed and adapted methodology how we will handle this. So yes, we are in the process of verification of those all information that we already archived. Thank you.
Thanks so much, Dennis. It looks like Tanya's back. Tanya, did you want to try continuing your presentation?
Yes, sorry for all these interruptions. I don't know what is happening to my internet today, but where is my oh, and I lost my presentation as well. 1 minute. Yes, okay. So do you see it now?
Not yet, Tanya.
No. This is a little bit. Okay, well, I mean, in the last case, I could continue without my presentation because I don't have it here. I change of desktop and somehow it disappeared.
That's okay. Would you like to continue without your presentation?
Yes, for sure. So, so like I was saying, so they justified their declaration of war with several regulations that relate directly to IHL. And so, I mean, this is very interesting because it's a non-state armed group who are unilaterally ascribing to comply with the rules of war. And act as a, okay, again, sorry, really sorry. So they asked the ICRC to act as a third party and monitor combat and also help civilians. And so that's what the ICRC did. So they declared war in January 1st, and the ICRC was already present on January 5, was already present in Chiapas. And so the ICRC arrived in Chiapas on June 1994, and their mission lasted 5 years. And the ICRC created free zones in Chiapas and established medical services. They also facilitated dialogue between the Zapatista Liberation Army and the Mexican government, and they provided assistance for the internally displaced. So as for the Mexican government, they never officially recognized the internal armed conflict. And on February 9, 1995, President Ernesto Zedillo issued an arrest warrant against Subcomandante Marcos for conspiracy and terrorism. Nevertheless, the Mexican government, through the Foreign Office, has explained that the participation of the ICRC was based on Common Article 3 of the Geneva Conventions. So here we see the classic example where states don't want to recognize non-state armed groups or the internal armed conflict, but at the same time, they allow the ICRC to operate there. And so this is also a nice example of these two, so to speak, contesting things we have sometimes in non-international armed conflict. And of course, the participation of the ICRC helped at, for example, the, I think maybe I can now, yes. So these are good example of how these two contesting visions apply, where there is the state not recognizing, and at the same time the non-state armed groups, and the presence of the ICRC, which, by the way, not only the ICRC was present, but also the Spanish Red Cross and the German Red Cross. And so I don't want to here last too much. So and if you want to learn more about how it operated in the ground, the ICRC as a third party, and making monitoring that civilians were not wounded, killed, as well as property, There is this article by Beatriz Mequevan, who was chief in the mission in Chiapas, which she explains with great detail how all this operated. And by the way, before I forget, in the declaration they did in 1994, it also relates a little bit to the parallel session we have on climate change, because they were also advocated in this declaration to the preservation of natural resources that were in their lands. Yes, and so here I want, if you want to know a little bit more about it, I also have a chapter this on my doctoral dissertation. So here I make a little bit of publicity from myself. And here I have a chapter about the implementation of humanitarian law by non-state actors during the armed conflict in Chiapas. And so this is it. I'm really sorry it's was all the time interrupted, but I'm glad to answer any questions or anything that was not clear during Q&A. Thank you very much, and apologize again. Thanks.
Thanks very much, Tanya. So we'll open it back up to questions to any of the panelists. Again, feel free to ask them in the meeting chat or directly to the panelists by addressing them and unmuting yourself. So I had a question for Dennis, which relates and overlaps quite a bit with the question that Gayatri asked. But I know specifically in the context of international criminal trials, Dennis, admissibility is a big challenge. Now, you touched on this in your presentation, and I'm sure the answer overlaps quite a bit with the answer relating to verification. But are there specific strategies and tactics that the coalition has adopted to overcome admissibility challenges or make sure that admissibility challenges don't arise in the first place that you think could be put into practice by other organizations with similar objectives in other conflict zones?
Just maybe, Georgia, let me clarify your question. Do you mean admissibility of evidences for legal proceedings or what?
Yeah, that's what I mean.
Sure, we are considering this challenge, and for sure for Ukrainian legal proceedings, criminal proceedings, evidences which we collect sometimes may create some challenges for accepting them to be considered by the law enforcement agencies and the courts. But for ICC, Office of Prosecutor, usually we try to submit evidences which we receive from witnesses and victims. And in this case, the Office of Prosecutor always has the possibility to re-interview these persons personally without any intermediary in the face of any public organization and so on. So this communication is confidential. For this reason, we are considering different positions, different evidences. Of course, we are trying to simplify and to make the same methodology for collecting evidence between all organizations, members of the coalition. But in spite of this, each of the organizations has its own methodology. And of course, we try to always, when we speak with public organizations and its members, I always try to remind them about guidelines which was recently or 1 year ago provided by ICC and Eurojust on the collection of evidences by the public organizations. So I believe that most of the evidences which we collect can be admissible for legal proceedings. but of course we can have some gaps in what we are doing now.
Thanks, Dennis. Were there any other questions that anyone had for any of the panelists that have presented today? I'll just read a question aloud that's come through in the meeting chat. It's a question for Lauren. When enforcing the protection of cultural property, how easy is it to distinguish between looted or smuggled items from genuine collectibles, for example, family heirlooms?
Thanks for the question. Arguably not easy. I think that's part of the problem with the trade as a whole, is that it's very difficult to distinguish between whether an object is licit or illicit. It's not as simple as looking at, drugs or arms, which we can determine can see whether they're legal or not based on just by looking at them. A lot of things come down to the documentation and the laws that were in place when those objects were taken from the source country. It's also become more challenging over time since I suppose our, especially in the West, our understandings of ethics and what collecting practices have developed and changed. And so as a family member may have collected an object which at the time might have been considered acceptable to do. Now there might be other questions. So we might see challenges in trying to sell an object now through an auction house where someone has said, well, this object has been in my family for years, but because the kind of standards of due diligence and ethics have changed in the last decade or so, it becomes much harder to sell that object without proper documentation. So we're in a bit of a middle ground, and it's definitely a gray area. And it's very hard to say, without more facts, really, whether something is absolutely, whether having just a family heirloom would absolutely be legal or not. So it's a big ongoing challenge.
Thanks so much, Lauren. We have another question that's come through to Gayatri from Emmanuel. The question is, since you referenced Hamas, how would you address Israel's criminal responsibility in the current Israel-Hamas war, taking into account the explicit statement and conduct of Israel to remove Gaza to the ground?
Thank you for your question, Emmanuel. Well, I do not have a straightforward answer to this question. It's like Georgia was saying earlier, it's precisely at times like these that you feel that international law is not really the last bastion of hope that it's meant to be. But I mean, it's interesting that you did pick up on the Hamas reference that I made, because as I read through that report, what I did see were huge parallels between what happened back then and what is happening currently. And if I may just piggyback off the incredible work that Dennis is doing, I think that's all we can do at this stage, where there is a lot of institutional as well as coalition support for a state like Israel to probably do what they want to without any consequences, at least not any immediate consequences. The most that can be done at this stage is documentation of what's happening. And hopefully in the future, once again, we will have some sort of a UN body or a fact-finding mission that actually does the job of collating all this evidence that's been gathered and explaining what it is that went wrong, and is that amounting to a violation of international humanitarian law and international human rights law or not. But which is why, I mean, it is important to move beyond state actors and also think about the contributions that non-state actors are making, not just in monitoring international law, but also what is their contribution to the creation of specific norms in international law and who those norms apply to. I think all of those matter quite significantly at times like these. But I don't have a straightforward answer.
Thanks so much, Gayatri. I'll just give everyone a moment. Is there any other questions that anyone would like to ask before we finish up this panel? Great, doesn't look like it. Thank you so much to Lauren, Dennis, Gayatri, and Tanya for such interesting presentations and discussion that followed. I will close off this breakout room in just a moment, which I think should send you all back to the main meeting room. But we're going to have a short 15-minute break before we start the next parallel session. So we'll leave the call open, but we won't be recommencing until 2 p.m. UK time. Thanks so much to the panelists and everyone for participating.
Thank you all, and apologies for the technical things. I hope everything was clear, even though these interruptions. But well,